3, 2, 1!
So guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott talks law. And in this episode, we shall be talking about the trial process under criminal procedure and practice. So during trial, we have 15 processes that occur during trial. We have 15 activities that happen during the trial process. And we're going to look at all of those activities so that we get the understanding of trial, of trial, or things that happen during the trial. So the trial process is that process that occur in court, and there are 15 processes that happen during trial. So the first one is where both parties have that obligation, the legal burden of proof and the evidential burden of proof. And the legal burden of proof is lies with the prosecuting side in criminal proceedings, and the prosecuting side is supposed to prove a matter beyond reasonable doubt and establish a prima facie case that will require a rebuttal by the defense side. So the onus of failing to prove the legal burden of proof will result to failure in entire case. So the prosecuting side is supposed to prove a matter beyond reasonable doubt and establish a prima facie case that will require a rebuttal. Evidential burden of proof, on the other hand, is that burden of adducing evidence. So this burden of proof lies on both the prosecuting side and the defense side. Both sides have that burden of adducing evidence to support their arguments or facts. So failure to adduce this evidential burden of proof will also result in the less chances of succeeding in that case. So the evidential burden of proof is on both sides, but it's largely on the defense side. So the prosecuting side has that obligation to create a prima facie, or to prove a matter beyond reasonable doubt. So in the case of Sawe versus Republic, the prosecuting side has that legal burden of proof, and the case of Wilmington versus DPP talks about the legal burden of proof. And this legal burden of proof is based on the doctrine of honors probandi. It's based on the doctrine of honors probandi and the standards of proof, the doctrine of honors probandi. So in the case of Wilson Wanjala versus Republic, silence should not amount to any inference as to the guilt. So if the person chooses to remain silent, does not mean that he's guilty. The guilty or not guilty is supposed to be based on the evidence that has been adduced and the facts that have been considered by the court, whether or not those facts are relevant to create a prima facie but not silent. So Dixon Nyakundi versus Republic, it talks about right against self-incrimination, that someone shall not produce evidence that will subject him or her to self-incrimination. But there is an exemption whereby self-incrimination can be produced, evidence can be produced against this right of self-incrimination. So in the case of Dixon Nyakundi versus Republic, someone has that right against self-incrimination. So has that right against self-incrimination, not to evidence produced against self-incrimination that will incriminate him. But exemptions are where the DNA is supposed to be conducted. So the court shall order a DNA samples to be conducted whether it deals with under sexual assault offenses. And under these circumstances, the rights of self-incrimination shall not be considered, shall be exempted. So in the case of Boniface Kyalo Mololo versus Republic, sexual assault court may direct a forensic sample and scientific testing, including DNA tests. So another occurrence that happened during trial is an opening speech, and this is a speech that is made by the prosecuting side that summarizes the entire proceeding, or that gives an overview of the case. And this statement is made under this opening speech shall not be taken as evidence against the prosecuting side. And you should note that failure to conduct an opening speech is not fatal, and the court is not supposed to rely on the opening speech or evidence adduced on the opening speech. So you shall not incriminate someone or the prosecuting side in statements made during the opening speech. This is just a speech to give a summary or an overview of the entire proceedings that is made by the prosecuting side. Another thing that happened during proceedings is the choice of witness, and the prosecuting side has the duty to call either witness in the form of PW1, PW2, PW3, depends on the number of witnesses that are there. So the prosecuting side has that duty to choose witnesses that are to appear, both the defense side and the accusing side, the prosecuting side. So in the case of Bukenya and others versus Uganda, the prosecuting side needs to call witnesses who may have relevant factual information. So these witnesses have that factual information that can help the prosecuting side to prove the existence of facts in issue. These witnesses have that factual information, and they shall be called to help in proving or supporting the evidence produced by the prosecuting side. In the case of Oluoch versus Republic, a fact may be proved by a single witness. A fact can be proved by a single witness. It does not mean that witnesses are supposed to be more than one. Even one witness can be used to prove a fact. But in cases where this a single witness is used, then this matter shall be exercised with a lot of care. A single witness so identification by a single witness should be supported with the greatest care. So in the case of Kasam Ukir versus Republic, the prosecuting side should exercise its discretion in choosing the relevant witness to appear. So the prosecuting side, if there are 3 witnesses in form of PW1, PW2, and PW3, is supposed to exercise its discretion. Which witness should appear first? The law does not give an order of witness that this witness should appear first. So it's upon the prosecuting side to determine who or the witness that are to appear first, depending on the relevance of that, which is the information that the witnesses have. So the prosecuting side can choose the witness who have that relevant factual information to appear first, and then the others shall follow. So in the case of Bare Mohammed versus Republic, insufficient evidence without a witness couldn't favor the prosecuting side. So the prosecuting side is supposed to have that cogent evidence, that evidence that's supposed to create a prima facie, that to exercise its burden of proof. But witnesses are not relevant here, even though the witnesses were not present. Then insufficient evidence by the prosecuting side shall not be relied upon by the court. So evidence is the important thing here. Then the witnesses are just supposed to cover up or to add up or to just assist in proving the case or supporting the evidence that has been adduced by the court. So insufficient evidence couldn't have favored without witness couldn't have favored the prosecuting side, according to the case of Bare Mohammed versus Republic. So the order of witness, the prosecution side should determine the order in which the witness are to appear, as it was said in the case of Roy Richard, Rilema, and another versus Republic. There is no law requiring a witness to be any particular witness to be called. So examination in chief, we have this is another process that happened. So we have the examination in chief, the cross-examination, and the re-examination, and this is covered for under section 145 of the Evidence Act. So section 145 subsection 1 and section 150 of the CPC, Criminal Procedure Code. So examination in chief is covered for from section 145 of the Evidence Act, and this is the exercise conducted by the prosecuting side. So the prosecuting side is supposed to conduct an examination in chief, and you should note that during examination in chief, no leading questions are allowed. No leading questions are allowed during the examination in chief, and except during the introductory part. So there is this introductory part where the prosecuting advocate or counsel may just request this witness to introduce himself by a name. Then their witness can be asked leading questions. So leading questions are those questions that require certain answers. They require certain answer, either yes or no. Were you present in this particular scene of crime? Yes. If you are present, those are the types of leading questions that require answers like yes or no. So those questions are not allowed during the examination in chief. Leading questions are not allowed during examination in chief. These leading questions are questions that suggest a desired answer. So leading questions are not required except in formal introductory part. So the second one is the cross-examination by the defense side. After an examination in chief by the prosecuting counsel or advocate, then it shall be followed by cross-examination. And this is just to test the demeanor of the witness. So that to reduce that 100% probativeness of the prosecuting side. So after the examination in chief, the defense counsel shall come during the cross-examination to cross-examine this witness that was subjected during the examination in chief to test the demeanor, and discovered from section 145 subsection 2 of the Evidence Act, the cross-examination. And in the case of Stephen versus Republic, all accused persons have the right to hear all evidence of cross-examination of all witnesses. So all accused persons have the right to hear all evidence for cross-examination of all witnesses. So under cross-examination, leading questions are allowed during cross-examination as opposed to examination in chief. Here, leading questions are allowed during cross-examination. And it was held so in the case of Simon Githaka Mulamba versus Republic. So you also have a re-examination that comes after cross-examination. And the purposes of re-examination is to clarify some issue that maybe the witness said some issues that were not relevant to the prosecuting side. So the prosecuting side just comes to clarify some issues that maybe the witness said something that he was not supposed to say, and the prosecuting side should come to clarify those issues so that it can be consistent with what it intends to achieve. So the purposes of examination is to clarify some issues, and is covered from section 145 subsection 3 of the Evidence Act. So after cross-examination, witnesses may be asked further questions by the court. So the examination must be confined on matters that arose during cross-examination. So once the prosecution has called all the witnesses, it then closes its case. So after the prosecution has called all its witnesses, then they have closed the case, and the prosecution may also call for an adjournment of the case, so that it call for extra witness to support the case. So if the court does not allow this, then the court should, where the court denies such an application, it must note down on record. So the questions from the court can also ask questions, and these questions are not supposed to fill the gaps on evidence that was not brought out. So the questions of the court must take care, must exercise caution in asking questions. So these questions by the court are not supposed to fill the gaps that were not, the gaps on evidence that were not given either on the prosecuting side or the defense side. But these questions are just supposed to ask, there must be relevant questions, not to fill the gaps on evidence. So a prima facie case is that case that upon a court can find it a prima facie case is that case that a court can establish that a binding of proof was established by the prosecuting side. So the prima facie case is covered from section 211 and 306 of the CPC. And prima facie case is one which a reasonable tribunal, properly exercising its mind to law and evidence, could convict if no explanation by the defense side is given. So a court can direct its mind that a binding of proof has been established and can convict this offense if no rebuttal has been given by the defense side. So in that case, we call it that there is a prima facie case has been established. And the case of Eustace Kibera Karini versus Republic, it was held so. So if a prima facie case is not established at the close of the prosecution, then the court should acquit the accused person. So the court is not supposed to is supposed to acquit the accused person if a prima facie case has not been established, and the court is not supposed to reason. The court's reasoning as to whether the prima facie case has been established is not supposed to be known, because it will be seen as prejudicing the defense side. So the court concludes a prima facie case. If the court concludes that a prima facie case has been established, it should not give reason as to how as that finding, because it appears that the court has made up its mind even without hearing the defense side. So it should not appear as the court has made up its mind. So let's look at the conduct of the defense. So the defense side is also supposed to conduct itself by calling up upon the witnesses that are supposed to help in supporting the evidence in form of PD1, potential witness of the defense side, PW1, 2, and 3. So the conduct of the defense, upon finding that accused case has the case to answer, the court may inform the accused person of the following rights according to section 306, 2 and 211 of the CPC. So these are the rights that the accused person has, and it was held so in the case of Hawe Ibrahim versus Republic. So to address court personal, there are 3 rights that the accused person has, and the court shall inform this accused person upon finding that the accused person has the right to answer. So to address the court personally or through an advocate, to give sworn or unsworn evidence. An accused person can give sworn or unsworn evidence. It depends on how it chooses or how it deems fit. To remain silent according to Article 2.1 of the Constitution of Kenya. So those are the 3 rights that the accused person have upon finding that they have a case to answer. They can either choose to remain silent, they can either choose to be represented by an advocate, they can never choose to give sworn or unsworn evidence. So if the accused person opts to give sworn evidence, then they should note that this sworn evidence shall be cross-examined. And if the accused person ought to give unsworn evidence, this unsworn evidence shall not be cross-examined, but they shall be recorded. They shall be put on record according to Section 306 of the 211 of the CPC. So if an accused person elects not to give evidence and makes unsworn statements or adduces evidence, the prosecuting side may sum up all the prosecuting case against the accused. So accused respond in relating how to proceed must be recorded under unsworn testimony or evidence. So in the case of John Waweru Nika versus Republic, unsworn statements by the accused should be recorded by the court, and it should be recorded by the court. So they should be recorded in full. So in the case of Odongo versus Republic, the court should not prompt accused person to enter or add or subtract or an unsworn statement. The court should not prompt an accused person to enter, subtract, unsworn statement. So the close of the defense case is another happening that happened during the trial. So the court should note that fact on record, and where the defense closes its case permanently easy because a denial of adjournment to call a witness or any other reason. So a court can close its case either to adjourn to call further witnesses, then the court should note it. Evidence in reply. When accused in his or her defense introduces a new evidence that the prosecuting side, having exercised due diligence, couldn't have reasonably foreseen, the court may allow the prosecuting to adduce evidence in rebuttal. So the accused side can also bring out new evidence that the prosecuting side wasn't aware about this evidence. So under this scenario, the court allows the prosecuting side to also adduce evidence in rebuttal to rebut that new evidence that was produced by the accused person according to Section 211 and 309 of the CPC. So calling of the witnesses by court. A court can call a new witness to appear in court other than those witnesses that appear for the prosecuting side and the defense side. So new witnesses can be called in court to just to prove some particular occurrences or things. So the court and these new witnesses that are called by the court shall be cross-examined by both the prosecuting side and the defense side. So the court at any stage of the trial can call any person or witness and cross-examine the person. So this person shall be cross-examined, and it was said so in the case of Juma Ali versus Republic and Section 150 of the CPC. The court shall give both the prosecuting side an opportunity to cross-examine so that not to prejudice any party, according to Section 150 of the CPC. So inability to raise a defense due to mental disability. So an accused person can also be unable to raise a defense because of that mental disability, and it's according to Section 162, subsection 2 of the CPC. So the court should determine and postpone the hearing. Can postpone the hearing, can release someone on bail, and it can also hold someone in safe custody if bail is unsuitable. This person shall be held in safe custody until he is able to become well or to be of sound mind. So at the 15th occurrence is that visit to locus in quo. And visit to locus in quo, this is where the court visits the scene of crime. The court visits the scene of crime to determine the evidence and to determine more evidence. So the court may visit the scene of crime only if necessary and to understand the evidence given. So the court may want to understand the particular evidence given, so the court can visit the scene of crime. It was held in the case of Yoka versus Republic. And we also have final submissions after, and it's according to section 213, 310, 311 of the CPC. So written submission should only be accepted with express consent of the accused person. Accused person shall give express consent to written submission. Andrew Diambo Otieno versus Republic court held that submission, the written submission in absence of express consent of an accused person, proceedings are null and void. So accused person shall express consent to written submissions, must have consented to those written submissions. So at the close of the case, both the prosecuting side and the accused are entitled to present submissions to court on both evidence and the law. So you must present submissions to court on both evidence and the law. So during trial, the prosecuting side is supposed to give the defense side the evidence that it intends to rely upon. Supposed to give the evidence. If they have the evidence, they must supposed to give the defense side the evidence, the number of witnesses that are supposed to appear. If there are expert opinion, then they're supposed to give the accused side all those evidence that they intend to rely upon. So that is the trial processes. The trial process, I think that the trial process. So during trial, you have that examination in chief, the re-examination, cross-examination. We have the conduct of the accused, the conduct of the prosecuting side, this opening speech, the speech that is made by the prosecuting side. Is not that evidence produced here is not supposed to be lied by the court. We also have conduct of an accused person. We also have failure of the accused person to raise an objection because of unsound mind and the order of witness, the order of witness. You can choose the witness depending on how you wish to. There's no law that requires a witness to appear in a particular manner. So that is the end of my lecture, and subscribe to Scott's Legal channel, like the episodes, and comment on the comment section on how you feel about the lectures, and have a nice day.